Hi guys, it's Kathy. I hope you're doing well. So we got a couple different ones today, but one of them is a new one for us. Alright, so the first thing we're going to see is Judge Sapporo with a landlord-tenant. He does civil, so we usually see him with landlord-tenant. We're going to do a quick landlord-tenant with him. Then the next case he has is going to be something new for us to ponder. It's new, so he doesn't come up with a decision today. But, we'll see what he thinks about it before we move away from him into a different judge. All right, here we go. Let's go to Indiana, guys. I've always wanted to go to Indiana. I wouldn't mind court hopping in Indiana. I would go to Cristofino first. I just would. I would go to Magistrate Link, definitely. I would go to Judge Fish, abso-freaking-lutely. He would be like the headliner. He would be like the last one. Hi, Christy. How are you? All right. Time to get to work, guys.
Okay, well, this takes care of a few people, so we're in good shape. All right. I usually don't have 6 people for one hearing, but I do today. Folks, this is an eviction hearing in the case of Dylan Lopez versus defendants Ryan. Is it Hostetler or Hostetler? Hostetler.
Oh, I gotta get Judge Cutie Pie. I have to, Josh. I work tomorrow, but maybe Friday if he's on.
And then Steve Riley.
I'm here for Steve Riley, power of attorney.
Okay. Is Steve Riley elderly or otherwise incapacitated?
He's got mobility issues, health problems.
I will share that under the trial rules, technically only attorneys can appear for others. Even if a person has a POA, they're technically not allowed to represent someone in court. But nonetheless, I will show that you are present. I don't know that we can.
That's kind of where I wanted his presence, I guess.
And then what is your name, sir?
Derek Corrigan.
And can you please spell that for the record?
Corrigan.
Again, please.
One more time. I'm sorry, I missed the two.
C like cat. Orrigan.
Corrigan?
Yeah.
And what was the first name?
Derek, Derek.
Thank you very much, like Jeter. All right. And then do I have, I already have Ryan host. I have a spot for unknown persons. Ma'am, do you reside at the real estate in question?
Yes, I do.
What is your name?
Leandra, Leandra, and then Kraft, just like the cheese, Kraft.
Thank you. All right. And do you have any objection to me amending the caption instead of having unknown person, have your name listed?
No.
Okay, then we'll go ahead and do that. Folks, were you in court when I made my pre-eviction diversion announcement?
Yes.
Okay, and then Ms. Whitmer, is there any interest in that program on the part of your clients?
No, Your Honor.
Okay. Ms. Whitmer, what is the status of things from the plaintiff's perspective?
Your Honor, this
I know Judge Cutie Pie's name is Brett, but I cannot remember his last name.
is a piece of inherited property. My client is Dylan Lopez. His uncle owned the property before, and the real estate was transferred to him by small estate affidavit, and he is of record, the owner of the place. He has attempted, these people are there, they have, and his mother is here with him. She has been helping him with this. They have attempted to contact these people. They have never been able. They knock on the door, there's no answer. When the original owner died, there were ambulances and all kinds of police and all that stuff. They never came out and said boo or showed their faces. So there is no landlord-tenant relationship between these people. In my opinion, they're simply, or my position is they're simply squatters. And they, at one point, the prior owner started an eviction action saying they were $18,000 in rent. He dismissed that for whatever reason, but we don't know. There is no written lease. They found nothing in his records. He never told them anything about this. It's it's our position that an order of immediate possession should be granted.
Okay, let me place at least the two defendants, named defendants who are here personally. Let me place each of you under oath if you'd each raise your respective right hands. Yes, I'm sorry, I should just tell you by name. Ms. Kraft and Mr. Hostetler. Do each of you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
Okay, I heard two yeses. I'll start with ladies first. Ms. Kraft, are you currently residing in the property in question?
Yes. Yes, I do.
And I'm gonna ask you a lot of questions. I'm gonna ask you for your patience. If you kindly just would answer the questions I ask in that order, I would appreciate it. Do you have a written lease with anyone regarding this property?
No.
Did you have any verbal understanding with anybody about your ability to possess the property?
Yes.
And what was that verbal understanding, and with whom was it struck?
That would be with the man that passed away, Mr. Silas. And well, Stephen moved in 2018. Okay, 2018 at the property. During COVID, when everybody, all that stuff was going on, and unemployment and everything was going on, Craig found out that I'm not sure what his illness was, but he had some type of illness. He lost his job, unfortunately, and he was going through a lot of things. So I offered him to give, because I was getting unemployment at the time, to pay a lump sum for the property, because he never wanted that piece of property anyways. He just wanted the back lot. The only reason why he got stuck with the front lot is because of an access problem to the back lot, so they couldn't be sold separately.
Question for you. You said pay a certain lump sum of money for the property. How much money was paid?
Paid $5,000.
Okay. Did you have a written agreement for the exchange of real estate?
No, because we could not.
Stop you.
Oh.
Because under Indiana law, any contract for real estate must be in writing.
This is the thing is, so the law that I looked at, because like I said, they said they could not sell the property separate, is that if we occupied that property for 10 years, then we could put in for the deed, as long as there was no paperwork and nobody, like this proceeding, of course, makes that null and void now, because there couldn't have been any proceedings or anything, you know.
It's only 8 years from 2018 at the moment.
Right, it's right. So we still needed 2 more years. So like if we can say, if you continue to let us stay there, it would start all the way over again before we could even think about getting a deed to the property.
Open, notorious, continuous, all the other adverse possession rules.
Mhm.
Let me ask, just to short circuit it, I'm not sure what your intentions are. By any chance, are the defendants in the process of moving out, or is that not begun?
No, we are not, because we've invested a lot of money into the property. The property was not livable when we moved in. We replaced the floors, the ceilings. We put in a wood burning stove because there was no heat to the property. All the appliances are ours. There was no bathroom. There was no working plumbing. We redid all the plumbing. We put 2 tons of gravel in the driveway, because the driveway was like impassable at times, especially during like today when it's real rainy. It's very muddy out there. We also, yeah, I mean, like, we've just invested so much time and money into this property.
Okay. Let me ask some questions of Ms. Whitmer. Ms. Whitmer, I'm guessing, but I don't like to guess or assume. Has an estate been opened in this county probate matter?
No, Your Honor, because the value was under $100,000, and so we did a small estate affidavit for transfer of real property. And that was really the only asset that decedent had.
And what was the date of death for the
I hope we're all learning what not to do with our lives. Not. I might go.
decedent?
April 25, 2025.
So next month will be a year. And what is the full name of uncle of Dylan Lopez?
Craig Siler, Siler. We didn't use the middle initial. I don't think it was on the real estate.
I'm glad you're out of the hospital.
Okay. To your knowledge, Ms. Whitmer, are there any creditors of Craig Siler?
No, there are not, to our knowledge. We searched through all his paperwork and found nothing other than, ongoing utilities and those types of things, which they have taken care of. In addition, they have paid the real estate taxes on the property.
Was there a recent payment, and did it cover only this year or many years?
Can I speak?
Yes,
I'm sorry.
I have to ask you for your full name. I usually do that on
I'm sorry.
You might want to swear her also, put her under oath.
Sure, please raise your right hand. Do you swear or affirm under pains and penalties of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God?
Absolutely, yes.
What is your name, ma'am?
Karen Lopez. The deceased was my brother.
Okay. And is the plaintiff Dylan Lopez your son?
Absolutely, yes.
Okay. And Ms. Lopez, what do you know about Craig Seiler's estate or his status of having creditors at the time of his death, et cetera?
My brother was unfortunately diagnosed with cancer, and so that's why he lost his job. My mother, we had the same mom, obviously. So we were taking care for 18 months, almost 2 years, taking care of all of his bills. We paid the taxes on the property.
Wait, you and your brother have the same mother? That's just weird.
For both lots, we paid everything. The property
You say
taxes.
the tax on the property for both
For
properties?
the real estate,
Both lots,
yes.
okay.
Yes, we paid all that. My mom paid it the first time, I paid it the second time, in excess of thousands of dollars. And so we were paying his utility bills, his heating, his everything, because he was unable to work. He was getting food stamps, he was on Medicaid, he was, radiation, dying, all this kind of things. I've never seen any of these people in my life, and we were at that property a million times. The evening when my brother passed away, like she said, coroner, fire trucks, ambulance, we have tried to contact these people. He started the proceedings in 22 to evict them for non-payment. The reason it was not followed through was because he was diagnosed with cancer and he was not able to drive. He was not able to get out there. He was in very poor health. He actually passed away in the home.
Right.
And so that's.
And your brother lived in the real estate in question until his death?
Absolutely. He owned it.
How many years?
He paid it off in 2017 is when he officially, he had no mortgage, no anything. It was paid off. He owned the house, the property, all of that. He lived there for approximately 7 years before he paid it off. He paid it off unfortunately, when our father passed away, we were given a lump sum of money and he paid the property off
Hi,
then.
Jen.
So he has been the sole owner of that property since 2017. But he lived there for a good 7-8 years before that. He had an elderly lady that he bought the property from.
Okay, thank you for that. I'm going to go back to the defense
No
table.
problem.
I have not yet heard from Mr. Hostetler. I've already placed you under oath. Mr. Hostetler, you heard Ms. Kraft's testimony a little bit earlier. Would you agree that there's no written lease or sale document related to this real estate, to your knowledge?
There was nothing signed.
What's your understanding of the verbal agreement?
Verbal agreement was pretty much what she stated, that said her and Stephen Riley made an agreement with Mr. Seiler about the property. Said that if they paid a lump sum to be there, that he would be okay with that. And that in the meantime, that if we fix the house up, we could live there in exchange for rent, pretty much.
So I heard you say if we paid a lump sum to be there. To me, when someone speaks of being there or having the right to stay there as a tenant, that's very different from a lump sum of money to purchase property. And in any event, without a written agreement, it wouldn't be binding. So I don't believe, based on the testimony of my two defendants so far, that I've got that agreement. But ma'am, you want to share something?
He was not there. This is my boyfriend. Okay,
Yeah,
the only
I
reason
wasn't-
why he is here is because his name is on the light
Yeah,
bill.
I don't know.
He's not been there.
Was
He
not there
doesn't-
when
he's
that
not-
happened.
He's not pertained to what is going on.
Yeah, I was not there
Okay.
when.
Okay, stop, folks. In everyday life, we talk over each other all the time, and it's okay.
Yes, I'm so
In
sorry.
court, I have a court reporter who needs to take down everything that is said. So it's very important that when one person is speaking, especially me, you don't speak out of turn, okay?
Except for
Now,
me.
Ms. Kraft, is there any?
Except for me, I can speak whenever I want to. Josh, I just went back up and looked, and I think I did see all the messages. Do you mean here in this chat? Because you asked about Cutie Pie, Brett. Or do you mean in a different type of chat? I don't have my phone on me.
anything else that you'd like to share with the court?
And also, yes, I would also like to share that I've never seen these people before. He was there. He was very much a loner. He did not have any company ever. And the day that he passed away, we did come outside. We were very much outside. I know there were some words exchanged between I don't know
birthday,
who,
father-in-law.
but I wave at them. I wave at them every time I see them outside. I wave. I say hello. No one has ever came up to talk to me. No one has ever come and knocked on my door to say 2 words to me. This is the first time I've ever even known their names, is when I got the summons to come to court. They have never had a discussion with me, never tried to have a discussion with me.
Time out. Thank you for the background.
Sorry.
What it really comes down to here, whether
Time out,
you
Bobby.
had lots of interactions or never had any interactions, the most important thing here is who owns the real estate.
Right.
And if at one time Mr. Seiler owned the real estate, and if that has been transferred to Dylan Lopez, then the property is Dylan Lopez. And if there's no deed of record or land contract of record or lease with option to purchase of record in writing signed by both parties, then there's really nothing that should hinder Mr. Lopez's rights of possession. So, please wait. So the main remaining question is, how long do you need to vacate the property?
I would need at least 60 to 90 days, because
3 months.
it takes money to leave. And again, like I said, I've invested all my money into this property. Like, the pipes burst every year. And
Okay, so I asked you for a date. You gave me 60 to 90 days.
Mhm.
I will tell you that is a lot longer than the court normally gives. If the
Yes.
court finds under normal circumstances that a plaintiff is entitled to immediate possession, typically my orders are for 10 days to 2 weeks. Sometimes I go 2 weeks so that I give people 2 weekends to move. If someone explains a hardship and needs more time, and if the plaintiff is willing to allow it, that's one story. But if the plaintiff is not willing to allow it, that's another. I would say, even without a written contract or lease, if you did stay beyond 10 days to 2 weeks, there certainly would be a fee for it, and you'd have to make whole the owner of the property for your use of the property, fair market value, during whatever amount of time you stayed. That being said, Ms. Whitmer, I saw some head nod, head shaking, indicating no desire to go longer. What is your client's maximum amount they'd allow?
I was able to silently communicate. Unfortunately, we have a damages hearing coming up before, but they indicated that they would consent to 30 days, but they really can't go longer than that. Oh, no, excuse me. I misspoke.
I'm sorry.
Your Honor.
Yeah, let me swear you in, since I've sworn in almost everybody else in the courtroom. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may put your hand down. What is your full legal name?
Dylan Kane Lopez.
And how do you spell Kane?
Kaine.
Thank you very much. And Mr. Lopez, you wanted to share something with the court?
Yes, I just wanted to share that at the end of January this year, we taped an eviction notice with contact information, with phone numbers on their door to start this process, and they never reached out to us one time. So the fact that they're saying that we didn't try, I'm just going to leave it at that. We left contact information. We were never contacted.
And Mr. Lopez, what would be the approximate date that you left that notice?
January
12th.
12th.
January 12th, excuse me. It was January 12th.
All right, and this lawsuit was not initiated until March.
Yes, we're trying to be nice,
Okay, thank you. Let me turn to the defendants. Either Ms. Kraft or Mr. Hostetler, did either of you see that notice in
He
January?
did not.
Have you, I think I heard you say earlier, Ms. Kraft, that Mr. Hostetler has not been at the property for some time, is that correct?
Oh, no, I didn't see this big piece of paper taped to my front door. No, sir, no.
When did he last live at the property?
No, he lives there now. He wasn't there at the beginning.
Oh, okay, thank you for that.
Mhm.
Have both of you had this real estate in question be your primary residence for at least the past couple of months, if not
Oh,
years?
yes, for the
Year.
at the least,
For me,
the last
yeah.
for him the last year, but for me at like the last 4 years.
Yeah.
I want to say.
So folks, there is a money damage hearing set for April 28th. That is 4 weeks from today. And typically we schedule those far enough out that someone can vacate and the plaintiff can have the opportunity to go in to do an inspection to determine what might be due and owing under the circumstances. And in a normal case where it's landlord tenant and there's a lease and it says, you know, $1,000 a month, they can say, okay, January, February, March rent, $1,000 a month, late fees. And then your lease says if you cause any damage to the property, you can be held responsible. And they need the chance to determine, you know, if somebody spilt red paint on the carpet or punched holes in the walls or otherwise destroyed something. So that's why we stagger it and have 2 hearings. Because the hearing is 28 days from today, I either need to give you a period shorter than 30 days, or I need to bump the damage hearing a little bit. Let me look at my calendar. So 21 days from now is April 21st. That would give 5 or 6 days for the plaintiff to go in and do an inspection before coming back to court on the 28th. What I'm going to do today, folks, is I'm going to find that the plaintiff is entitled to immediate possession. I'm going to issue what's called a writ of restitution. That's a fancy word for the piece of paper that the sheriff carries to effectuate an eviction. He will likely serve that in the next few days, and that will say on it that by noon on Tuesday, April 21st, you need to vacate the property. Now, I heard there be reference certain improvements, etc. I will point out to you, your paperwork likely said that at least 10 days before the next hearing date, the money damage hearing date, or the trial, you need to file any counterclaim you wish to counterclaim. So if you would like to do that, I would say that would need to be done no later than Friday, April 17th. That'll give a full 10, 11 days before the money damage hearing.
Okay.
Any questions about any of that?
No.
Any questions on the part of the plaintiff?
I don't believe so at this time. Do you have questions? They have 21.
So you have 21 days to go.
And the 21st.
And I will look at the complaint one more time. Ms. Whitmer, was this filed under a small claims EV or a plenary docket EV?
A small claims, we waive damages in excess of $10,000.
Okay, let me take a peek at the statement of claim.
I love pea soup.
It looks like it was
And ham
filed in the
or
style
without
of a non-small claim. It's like a complaint and a separate summons instead of the statement of claim with notice of
I
hearing.
did that, but then we refiled using the most recent filings are the small claims filings. I apologize for my confusion.
All right, that's okay. Let me just set my eyes on more recent files. Statement of claim, got it.
All right, guys, real quick. Since it's the evening for us in the United States, and most of the Australians are not here for this stream because they're busy at this time of the day, we should do something. We should do something. It would be so funny, all right? Listen, how about we do it Monday? That'll give us time to get ready. All right, are you ready for this? Everybody, each of you find an Australian type dinner. Food they make in Australia that they don't really make here, all right? And make it for dinner. And then when we come into the stream on Monday, we can all describe our dinners. Like, oh, this is what I had last night. I don't know an example because I don't. I made a sausage sizzle. I made a sausage sizzle at home. Confuse them all. They would be confused. They'd be like, what? What do you mean? I made a sausage sizzle with Vegemite. There, and I drank a Foster's. No, don't say Foster's. They get really upset. But we should do that. We should all cook something Australian and discuss it in the stream the next day. And they'll be floored. They won't know what's going on. I'm going to. No, Bobby. Bobby, what is wrong with you? No. Absolutely not. I'll figure out something. We'll figure out something. Just Google it and make it.
Okay, so the statement of claim is seeking up to $10,000. eviction due to unpaid rent. Tenants have no written lease and stopped paying rent in 2022, now owing more than $18,000. Notice to quit given January 12 and still no rent paid. Ms. Whitmer, were the rights to collect proceeds transferred from Mr. Seiler to Mr. Dylan Lopez?
Again, Your Honor, by small estate affidavit.
All right, so those are your claims. When we come back on April 28th at 3 p.m., we'll talk about not only that claim, but any counterclaim that is timely filed no later than Friday, April 17th. And then if we have some agreement at that time, wonderful. If we don't, typically we don't hold the trials at the time of the next hearing. We just give information about when that's going to be scheduled. And quite frankly, my magistrate, Dean Burton, is the judicial officer that typically hears those trials. He has a courtroom in this building, but it's 2 courtrooms down. It's on this floor. He's 4A, I'm 4C. So if we don't resolve it at the next hearing, it'll likely be set a month after that on Magistrate Burton's calendar.
Your Honor, I would advise the court that my clients have indicated that if the defendants vacate the premises without damaging them, they would be willing to waive all claims for damages just to be done with this matter. So I thought it important that the defendants know that, so that if that occurs, then we could simply cancel the damage hearing.
Okay, so what?
Oof, that damage hearing is going to be interesting. And we won't get to see it, but that's going to be interesting because, let's say, I doubt it. I really, really have huge doubts. Huge. But let's say they can provide proof that they put on a new roof, that they installed new floors, that they put up walls, there was no water, that they got a water heater and things like that. It could go from them owing $18,000 to them getting paid $12,000. You know what I mean? Yeah, you grind it down and you make it out of the popcorn kernels. I wanted to try it a couple times, but I haven't made it yet, but I do want to try it.
What I'll do is this. I will encourage you folks to speak outside of court. Usually when an attorney files an appearance, it will have the attorney's phone number, email address, etc. So there should be a way to get a hold of each other. But just for ease, because I know the phone numbers might not be readily accessible, would either Ms. Kraft or Mr. Hostetler be willing to share a phone
I
number?
will gladly give you my phone number. It is
And Mr. Hostetler, do you have a different number, or would you prefer things go through Ms. Kraft?
Go.
Protected her
What do you
from
mean?
that's
Bobby.
fine.
Okay, 574.
5333.
Yeah, a lot of 3.
Don't tell unless you want to, Josh, but what type of meat is it? You don't have to tell that either. I've heard of
And then
that.
especially when I have common names, I like to ask for dates of birth so we always know we have the right defendant. I'll start with Ms. Kraft. What is your date of birth?
Mine's 10/26/1988.
Okay. And then Mr. Hostetler, what is yours?
8/16/84.
All right. Mr. Riley is not here for himself, and I am not sure, Mr. Corrigan, if you know Mr. Riley's date of birth. Do you know it by chance?
It's 10/24/1970.
10/24/1970. Okay. Now we have it for all 3 named defendants. And Ms. Whitmer, just in all fairness, the defendants gave a phone number. Do you have a phone number handy so maybe they could write it down on one of our pieces of paper and they won't have to search for it?
Certainly. My office, and there is a message machine
Ms.
in case
Whitmer?
we're not there.
How'd you
Jay
spell your last-
Whitmer. WHITMER.
No, Michael.
So I'll close the
Unless
hearing
it's
by
deep
saying,
fried.
I encourage you folks to speak in advance of April 28th. If you speak in advance and if you reach some resolution that fully resolves all issues, the complaint, any waiver, any agreement not to pursue rent or damages, any counterclaim issues, if everything's resolved, if you let the court know in advance, we can vacate the hearing, cancel it. Nobody has to take a day off of work and come here or pay their lawyer to come here. But if you don't reach agreement, well, that's what the hearing's for. Come back. We'll take inventory of where things stand, and we'll determine if we need a trial setting or something else at that time. Okay. All right, folks. I wish you all good luck. Take care of yourself.
Thank
Thank
you so
you, Your Honor.
much.
Welcome. It's attorney William Ballou.
Okay, here we go, guys. We have Victoria, my love. Don't tell Michael I said that, okay? Because Michael will think I'm obsessed with you, and he'll think that he has to compete with me for you, and then he'll get upset. Don't tell Michael I said that. Hi, Victoria. Hi. Anyway, guys, we got Victoria here from Court 5. Now oh yeah, okay, guys, get ready. All right, because this is a different hearing than we've ever seen before, and the judge doesn't know what to do, so we don't get a verdict. I don't know what the judge should do. I feel like this guy has a point, and a strong point, and I think I agree with him.
All right, this is a first hearing on a small claim. Give me a moment to pull this up on my docket.
There's one thing the judge says that I don't agree with, but I think he knows more than me about the law.
All right, I see the statement of claim was filed in late February 24th. It was entered on the 27th, and it states, I served 1 year probation and paid court costs and probation fees as well. My case went to the appellate court and was overturned twice. So at this time, I'm asking the county to reimburse me the funds I paid to the clerk. 2017 Nelson v. Colorado U.S. Supreme Court by Justice Ruth Bader Ginsburg states that no state has the right to claim funds. States must refund all court costs and restitution when the conviction was overturned. I must say this is the first time I've had a reimbursement of court costs in a criminal case come before me in a civil court, but I understand the claim.
What do you think? Should he get all of his money back? Victoria, I don't know if Judge Fleischer received it yet, but one of our Vibers, Eileen, created a binder full of Fleischerisms with illustrations and sent it to him. I don't know if he received it yet, but hi, James.
I followed. Am I correct, sir? Were you convicted at the trial court level before?
I was convicted, and I took it to appellate court. While it was in appellate court, I served a whole year on probation.
Okay.
And I paid my court costs and fines. And I'm just asking to be reimbursed since it was overturned. My conviction was overturned, Your Honor.
Okay. And you said it was appealed twice.
It was appealed twice.
It went up to the Court of Appeals.
It went up to the Court of Appeals. They overturned it. Then they also overturned it so that the judge could not refile. They said that the judge submitted something in writing to retry, and they denied her request.
Okay. All right. Let me ask Mr. Ballou, what is the defendant's response?
Yes, Your Honor. We would like to orally move for dismissal on 2 rounds, one being location and 2 being improper defendant.
I didn't hear the first one.
Sir, like location, it's the wrong court for this motion. Do you mind if I go into why and the reasoning?
You may. I might ask if you can move that microphone a little bit closer. I'm having a hard time hearing you for some reason.
Sure. Is that better?
Much better.
Gotcha. So one, the first.
Why is it people get hard of hearing when we're talking about money? Pay him. Pay him his money.
That the fees and costs seeking to be reimbursed come from an order in a criminal court and from the criminal process. So any challenge to that process should be litigated there as well. The order for payment of court costs and probation fees was entered in August of 2024, which is a standard part of criminal proceedings. And the actions for ordering and collecting these fees are entirely administrative in nature. If he's trying to recover these fees, he should raise that issue in criminal court, as that is the right place for decision to be made regarding criminal process. This is not the correct place to seek that recovery, as it would require a civil court to modify or alter the outcome of a criminal proceeding. And ultimately, it appears to be a collateral attack on order or process from another court. So instead of creating an entirely new action in civil court, it should remain with the court that has overseen the entirety of the process to this point. Secondarily, naming Elkhart County as defendant by statute means also naming the Elkhart County Board of Commissioners, as they are the executive for Elkhart County. As can be seen in Indiana Code section 36-2-2-2. Neither Elkhart County or the Elkhart County Board of Commissioners have anything to do with this case or any criminal case. Additionally, Elkhart County does not set or enforce court costs or filing fees. It also does not have the authority to remove, modify, or waive court costs. So it seems improper to have the county named as the defendant in this matter. And lastly, it just would appear to set a potentially dangerous precedent if the county is being held responsible for reimbursing every court cost and probation fee for any conviction that is overturned. And for those reasons, we move for dismissal.
But you should. But you sort of should. I mean, if I get prosecuted for a crime I did not commit, and I have to pay $2,000 to fix everything, GPS tests, drug tests, whatever, probation fees, lawyers, then, and I didn't do anything wrong, then yeah, you should pay me you should. You need to prosecute people who broke the law.
Of the small claim, and failing that, just for the dismissal of Elkhart County as the defendant.
Okay. So let me share, Mr. McBride. I could do one of a couple of things. I certainly can give you the opportunity to respond verbally in court today, but I recognize this is the first time you've heard the oral motion to dismiss and the reasoning for it. So I'm also happy to give you time to research, hire counsel if you want, file a response brief to any motion. Another possibility is if you have heard the defendant's argument and if you believe that, hey, I didn't know that, but now that I've heard it, maybe I'll petition the criminal court to reverse those fines. You could do that, and this court could either stay these proceedings and not take any more action, or dismiss it without prejudice, meaning we could reopen it if it were ever determined that it would be appropriate to hear it in the civil court.
Okay.
Do you have any preference based on all the different options I just laid out?
I did what I was told to do by Superior Court Judge in Superior Court 1.
Okay.
I took Elkhart County to court since they are the ones that collected the fees. That's the reason why I took Elkhart County to court.
Okay.
To get those fees back.
And I understand the basis.
And he's trying to say that I can't take Elkhart County to court because the Elkhart County commissioners are not part of any criminal court. I understand that. But they was good enough to take my money. Do they understand that?
Mm-hmm. Do you understand the plaintiff's argument?
Yes, Your Honor.
Gentlemen, what I think might be most appropriate would be to leave this case pending, but to give the opportunity, instead of doing this orally, for the defendant, if the defendant has a motion to dismiss, to file a written motion to dismiss along with a memorandum of law.
Okay, here's where he says something I don't agree with, but apparently it's the law.
And then typically I will give between 20 and 30 days. I can give 30 days in case you want to have a little extra time for trying to hire a lawyer. Give that amount of time for the plaintiff to file a response to the motion to dismiss along with a memorandum of law and any authority that plaintiff feels justify keeping the case in this civil court. I will share, this is a first impression issue for me. I've not touched it.
With the understanding that that if I have to hire an attorney, I'm going for attorney fees as well.
Well, I will share with you, under Indiana law, the general rule is that everybody pays for their own lawyer in litigation unless, and the unless normally means unless there's a contract that says if someone breaches it, they must pay, or unless there's a statute, like in landlord-tenant or employer-employee cases where statutes say that.
What about criminal court?
I don't know that there's a statute that prescribes that if a suit needs to be brought,
That's not fair. I disagree with that 1,000 trillion percent. If he has to get an attorney, which he might need to figure all this mess out, if Superior Court told him to go, Superior Court 1 told him to go to Superior Court 5, he went to Superior Court 5, Superior Court 5 told him to go back to Superior Court, he might need a lawyer, or he's just going to get, passed back and forth forever. But if he pays for a lawyer, that's all the money like he was going to get. He's out thousands of dollars still, and he never committed the crime.
the criminal defendant who had a conviction overturned is entitled to reimbursement of court. I'm not aware of that statute if there is one, but that's why I'm giving you the opportunity to file a written memorandum of law in response. Okay. Gentlemen, I won't set another hearing at this time. I won't refer the matter for trial either. I will simply await the written motion to dismiss and a memorandum and then plaintiff's response. If the defendant would like to reply to that, I typically give 10 or 15 days after the response comes in. And then I will rule on it on paper unless one of you says, Judge, I want another oral argument. I want to come in and be able to verbally state what I've put in my brief and have a little dialogue about it. So we don't.
Yo, if I were him now, because of all this happening, I would add on pain and suffering, psychiatrists, because, you know, he was convicted of a crime, he lost job opportunities. I would start getting my calculator out. I would.
Normally need to do that unless somebody really wants it. Any questions about anything I just said?
This is actually an adding machine, not a calculator. But if I said adding machine, all the youngsters in here would say, what? Just kidding, there's no youngsters in here.
Your Honor, at this point, with everything I've been through, I'm ready to argue to the moon over this.
Okay. And you have that right.
Go,
and I will
sir.
give it a look as I started to say before.
So much.
This is an
Thank
issue
you.
of first impression for me. I've never had this issue before.
And that's what the judge said in Superior Court 1, 2.
Okay, so it doesn't happen every day.
That's the first.
But I will certainly take a look at the law that is cited, the arguments that are made, and I'll make an informed decision based on the law. I can't tell you right now who's going to be happy and who's going to be sad, but I can almost guarantee you it won't be that both people are happy. It's going to be one side ecstatic and one side not very happy. And I don't know which way that's going to fall as we sit here right now. But I'll await the written filings, and I wish you a good afternoon, gentlemen.
Thank you.
Take care.
You guys have been very generous with memberships lately, and I'm very thankful because people really do love the memberships. It makes them happy. I'm going to put more member-only content up there so that the people who have a new membership can go and like watch something different. You know what? Maybe I'll put new judges. Maybe what I'll do is I'll find a brand new judge. Whether it's good content or not, I can't promise because, look, I'm one person and I'm stretched real thin right now. But what I can do is I can promise to get a new judge, a few minutes of a new judge, up in members only more frequently. Since I'm not doing it at all now, more frequently could mean anything. But be quiet. And that way you guys can see judges that no one else is playing. If you're a member, I think that'll work. I think that's what I'm gonna do. I just need more time in the day, guys. More time in the day. Bye, V. Okay, now we're going to go to. Ooh, okay. Here we go, guys. Oof, oof is all I can say about this one. Oof.
Okay, next we've got the matter of indirect contempt of Alicia Glassburn, 20D042603 MI92, as well as State versus Alicia Glassburn, since they're related to the contempt, 20D042011 CM 1481 and 20D042312 CM 2154 contendor/defendant.
I genuinely feel bad for every single one of my past sins after I hear this judge talk to this woman. I feel guilty. I feel like I did something wrong and I need to go fix it. James, thank you so much. I appreciate it. Now, James, sit back and get yelled at. Get ready.
That appears
He's
in
not gonna
person in
yell.
custody, produced by the sheriff and with her counsel, Michael Bannock. Ms. Glassburn, do you swear or affirm any testimony you'll give today will be the truth?
Yes.
State your name, please.
Alicia Mangucha,
What's your date of birth?
August 26, 1984.
19. Can you still receive mail at? Oh, we still have the jail as, you want me to just confirm that?
Yeah.
Okay, it's fine then. Assistant. Okay, Mr. Bannick, this is a continuation from a couple of weeks ago on the indirect contempt. I guess I'll ask you what do you want to do today?
Well, from my discussions with, Alicia, she's acknowledging that she did not follow the court orders. The contempt is kind of the court's show, so I leave it in your hands.
Okay, so there's no legal or procedural dispute is what you're saying?
Correct.
I shouldn't have said yelled. That was my fault. He doesn't yell. It's worse. It's so much worse. I would rather be yelled at than what he does.
Need to get into the, okay.
Yeah.
So then, Ms. Glassburn, I'm calling you that just because that's what the status, or the case is still, we don't change people's names even if they get married. So if I call you, is that all right if I call you Ms. Glassburn? Okay. Okay, so as you're aware, the court had granted you actually two furloughs. Well, I granted you two furloughs in a row. I think that there may have been other furloughs before the two that I granted, and they're not even really a part of this. But the most recent furlough on March 13th, 2026 was granted at your attorney's request on your behalf to attend your mother's funeral. And the order did state that, when you had to be back by. Okay, so the furlough order required that you return to the Elkhart County Jail on or before Saturday, March 14, 2026 at 4:00 p.m. It says failure to return by that date shall result in a finding of contempt and shall result in additional sanctions for the defendant. The court was informed by the jail that you did not return until approximately it takes me a moment because I got to switch between criminal cases and civil cases to get back and forth. That you did not return to the jail until approximately 12:05 on Sunday, March 15th, which, if true, is a little over 8 hours after you were supposed to return. So is it true that you did not return to the jail by the time you were ordered to return? Okay, and I need to know why. And you're under oath.
I don't have some big elaborate story. I'm not gonna disrespect you by lying. I hadn't slept in days. I'm really sick. I'm not getting the right treatment there that I need. I'm just gonna start chemo again soon. I hadn't slept in days. My mom just died. I was just exhausted. We had about an hour and a half after the funeral before I had to come back. I sat down at the house and we just fell asleep, and I came back as soon as I woke up.
How did you get back to the jail?
My husband. We had set an alarm, but the phone, I have an iPhone and the alarm still goes off when it's on silent on my phone, but it was on his phone and it's an Android. So when we set it, it was on silent from the funeral, and the alarm just never heard it because it was just vibrating.
At the house, who was, when you're saying that you were asleep, who all was at your house?
Just me and my husband.
Well, was he asleep?
Yeah, we both went to, when we sat down, we both just fell asleep. And then when I woke up, I came back to the jail as soon as I woke up.
Well, what time did you wake up?
About 11, it was 11:30 that night. I said I hadn't slept, I feel like I hadn't slept in days. I almost passed out at the funeral. I was sick. I just fell asleep and my body shut down. I didn't wake up until about 11:30.
Why didn't you just go back to the jail after the funeral so that you could avoid any of this possibility?
I guess because I really wanted to have whatever time I could with him while I was out. I know it was only an hour and a half, but an hour and a half was a little bit more time out of jail than, I apologize.
What time did the funeral start?
The funeral started at 11.
Mr. Bannick, do you have any questions for your client?
I don't have any questions. I have a few comments to make as far as sanctions.
Does the state have any questions?
Just briefly, so Ms. Glassburn, just so I can understand, so you acknowledge that you're supposed to get to the jail at a specific time, right?
Yes, sir.
And your testimony is that you didn't.
Yeah.
Is the reason you're giving because you fell asleep after the funeral?
After the funeral, yeah.
Okay, and did an alarm go up, or
No,
they
it's
just
just
naturally rise?
Yeah, I we have the alarm, his phone was on silent still from the funeral, so we never even heard it, because it was just vibrating.
Okay. And your testimony is that as soon as you woke up, you realized that, oh, we have to go to the jail?
Yeah.
Only question.
Okay. Arguments, Mr. Bannock?
She was
Your Honor,
8 hours late.
Alicia, if you look back into her case, I believe that Judge Bellin was from time to time cutting her loose on furloughs because she does suffer from cancer and she has a number of other ailments. The judge did not extend the furlough again along the way, but, and if I am understanding correct from her, I've not verified this with the jail. I mean, she's within weeks of being done with her sentences, aside from the fact that she has this contempt hearing. What she did wasn't terribly right, wasn't something that anyone can condone. I don't think she was trying to flaunt any court orders. She's been very sick herself. She wasn't sleeping, she reports to me, because her mother was in hospice and then she was going to attend the funeral and did attend the funeral and fell asleep. And it was no excuse for that, but I would hope to not heavily punish for that either. That's all I have to say.
State, if you wish to make any sort of recommendation or argument, by all means, go ahead. You know, this is kind of an odd situation because it's contempt, and I suppose there's an argument to be made that the state's not involved. But I will say, regardless of that, the first of the two contempts, I reached out to both of you to see if the state had any objection to the first of the two, and the state did not. So, you know, you're involved in a manner of speaking. If you have an argument you want to make regarding sanctions, I'll hear it.
I mean, I would just say if there's, I mean, assume it's last word is telling the truth. I guess it does appear there wasn't anything malicious about it. You know, it seemed like the jail asserted, you know, that, okay, she came back and there was some sort of illegal drug use or anything like that.
I don't know. I was thinking about, I mean, you're not going to be charged with anything. Did you consume anything?
No, I just came right back. We went to the funeral. I didn't even eat, actually. Like I said, I almost passed out. I had a Snapple apple there, and then that's all I had the entire day, and went back to the jail.
Sorry, go ahead, Mr. Nick.
Right, so based on what we have, as soon as she's telling the truth, then I would agree the sanction should be flattened, since it wasn't malicious.
Right. Ms. Glassmer, what would you like to say, if anything, regarding sanctions?
I just want to apologize and thank you for giving me the opportunity to go see my mom before she actually passed and for going to the funeral, and I apologize again.
It is not a secret that I don't grant furloughs very often. I'm not a heartless person. I don't believe I have ever granted a furlough for a funeral in my entire career, because I've seen people who are released to go to a funeral and they either don't return. This is in other courts or situations, not mine. Or I've seen somebody overdose on drugs and die, and it was found in a pond behind the movie theater. And to the best of my knowledge, this is the first and only time I've granted a furlough for a funeral. And I do that, and I have to be told by the jail that you didn't even come back when I told you to. And that's really disheartening, because I'm going to think about that the next time there's a funeral furlough request made by someone else. You can't have a hat on in the courtroom. I presume that everybody who testifies under oath is telling the truth. I presume you are. I presume that all that happened was what you stated, that you overslept. I am in no way condoning or making light of the situation. You did not return when you were ordered to. but you did return. On the totem pole of egregiousness, it's not a situation where, for example, you just failed to return and you're still missing. I think there's an argument to be made that if you were possibly out there committing other offenses or consuming illegal drugs, that you wouldn't have returned as soon as you did. And we're talking about a window of 8 hours. But it is still unacceptable that you're given a gift that almost no one else is given. And by the way, if it means anything, there is no law in Indiana, nothing, no law on the books that allows for a furlough. It doesn't exist in Indiana. It's a made up thing. Do the research if you don't believe me. There's no such thing in the law as a furlough. We as judges, I don't know where we've come up with it. Almost everybody knows the word furlough, but it doesn't even exist in the law. Yet we still do it under certain circumstances. And I'm disappointed in you, and I'm disappointed that I gave you this opportunity and you didn't follow through. Now, the furlough I gave you, whatever.
Judge, we are all sorry. Every single one of us is so sorry. We did not mean to disappoint you and ruin it for everybody else forever and ever and ever.
Was it weird? So earlier, I didn't hear, or I wasn't told that you didn't return on time, which is exactly why I gave you the second furlough. I do agree with both of the attorneys that based upon the facts of what happened, and I have no reason to dispute what the veracity of what you stated, that a serious punishment is not necessary. What is the right punishment? I mean, there's no book on this. There's no sentencing tool for contempt. The sentences in each case were already ordered consecutive. And so here's what I'm going to impose. I'm going to sentence you to serve 5 days in each case in the Elkhart County Jail, consecutive for a total of 10 days. And I didn't know what I was going to hear today, and I didn't prejudge this. I feel better now hearing the explanation that you gave. And again, I hope I'm being told the truth. I know people lie to me under oath. It's sad, but it's true. But I don't have any reason to doubt. The explanation that you gave me is a lot better than what I thought I was going to hear. And that's why the sanction isn't more than it was, which probably would have been more in the lines of 45 days in each case, for which would have been 3 more months in jail. Pursuant to appellate case law holdings, you do not receive any good time credit. And so it is I'm wording it a certain way. The contempt case itself is one specific case number. So even though I'm telling you verbally that the overall punishment is 5 days in each case, in the order, it's going to be 10 days as the sanction. I'm just explaining it as I'm more or less attributing 5 days to each case. So for the indirect contempt of court, I'm going to sanction you to serve 10 days in the Elkhart County Jail without any good time credit. That means that your release date from the jail is now extended by 10 actual days. Now, the jail is going to get the order. I'm going to do a written order. And in relation to all of this, because of the history of the furloughs and all of that, and the fact that they're going to have to adjust your out date. I'll put that in the order that they also need to take a look at to make sure that everything is done correctly. The days that you weren't in jail to correctly identify and calculate your out date. But whatever it is, if your current out date is still correct, add 10 days to that. You have the right to appeal the sanctions imposed herein. In order to do so, you must file either a notice of appeal or a motion to correct error within 30 days of today's date. If you elect to file a motion to correct error, you must file your notice of appeal within 30 days of an adverse ruling on that motion. Failure to comply with these requirements will result in the forfeiture of your right to appeal. You have a right to be represented by counsel at all stages of these proceedings, including any appeal which you may wish to pursue. If you're unable to afford an attorney, I'm obligated to appoint one to represent you at no cost. Is it your desire to appeal to the Indiana Court of Appeals the finding of the contempt or the sanctions imposed or both?
No, sir.
Okay, I'm going to show that contemnor has been advised of her appellate right. She declines to appeal. As a state, I mean, you're gonna be out of the jail fairly soon. As a statement of the obvious, Ms. Glassburn, do not ask me for another furlough. It is not going to happen.
I don't plan
You
to do
just
that
need to
here.
finish your sentence and be done with it. I do wish you the best of luck. I'm very sorry about your mother's passing. Mr. Bannick, I'm assuming you want me to withdraw your appearance in all three cases.
Across all the cases.
So I'm gonna withdraw Mr. Bannick's appearance. So I do wish you the best of luck. Anything else from anybody?
I don't believe so, Your Honor.
Good luck to you and your family. Thank you. Okay, Mr. Bannick, I think that's all you had to do today.
Yes, that's all.
Have a good.
This is Judge Ditton, I believe. And you know how he said he's not heartless? Okay, I'm not going to say he's heartless, but I'm not going to say he's not heartless. There are some times this judge, so he's not going to yell and he's not going to scream at someone. He's not going to get riled up. He's not going to try to one-up somebody who's annoying him. He is going to lay down the law, and he wields a huge hammer sometimes. So, if you mess around with this judge, first just don't. Because he adds months, he adds years, he adds days, almost always consecutive, almost always straight time. So like in Indiana, you get good time. No, not when you mess with this judge. So he's not heartless, but he is definitely not a pushover. And if you mess with him, he believed her. An 8-hour nap seems a bit much to me. Like 3 hours, 2 hours, I might understand. Because it was 2 adults that did it. Her and her husband fell asleep for 8 hours. Now, if my wife was in jail for an extended period of time and got a furlough, I just don't believe sleeping would be on the list of things that are done that day. I just don't. So I don't know. I don't know if I believe that she was asleep for 8 hours. I just don't know. He did though. He gave her the benefit of the doubt. She was almost done with her time. She had a couple weeks left of her time, and now she has 10 more days added to the end of it. All right, we are going to go to Judge Link. This is another judge you can only see here right now. I don't know, and maybe American courts. Sorry, you can only see here and maybe American courts. Anyway, this is Magistrate Link. When he is good, he is the best I could ask for. He's not in that league right here, but he's okay. He'll do. Please? Alright, it's not letting me. It's just saying, no, Kathy, you're not playing Magistrate Link today. Let's try again. Let's just cancel out and try again. Something always goes wrong every stream. I don't know why it just can't work. There we go.
46D04 2603 F6 349. Mr. Keithsburg appears by video without counsel for initial hearing. Mr. Keithsburg, were you advised of your rights before court?
Yes, Your Honor.
Do you understand what your rights are in this case?
Yes, Your Honor.
Do you have any questions about your rights today?
No, but my old lady tried to get these charges dropped. She has seizures, Your Honor, and when I was in the shower, I came out and I didn't know she was coming out of one. She was laying in the bed. She got like.
Hold on, Mr. Keithsburg. You have the right to remain silent and the right against self-incrimination. You don't have an attorney today, so I don't want you to violate your rights because anything you say in this hearing can be used against you in this case.
Right.
Today's not the date to get into what happened or didn't happen or the facts of the case. As far as whether or not the complaining witness is trying to drop the charges or not, that doesn't really matter for today's case, and it's the state of Indiana that brings the charges, not the alleged victim.
Right.
So we're not going to get into all that, is what I'm telling you today, okay?
I got one more question. I don't mean to interrupt. She is struggling to cover. We're living in the King's Inn Motel. She's on a GPS monitor. Her power of attorney, I got payee over her. She can't handle finances. That monitor is killing her finances. She only makes $600 a month, and she can't cover the room. Is there any way I could get an OR so I could go back to her and help her? Because without me out there, she can't afford to do anything. I have a job lined up. I'm supposed to be starting back at the Brewery Lodge Supper Club sometime next week. I'm supposed to go fill out my tax papers for that. And I hate to see her in a situation like that.
Here's the problem. There's two problems. The level of charges are 2 felonies. So an OR bond is not going to be possible. The second problem is there's going to be a no contact order preventing you from having any contact with Bobby Callahan. So
still together, how's that going to work? I'm getting ready to marry her. We just got a court date for her divorce.
You're going to have to postpone that and not have any contact until this case gets resolved. So
he told me to give you her number for the prosecuting attorney to contact her because she doesn't want these charges on me. I got a recorded phone call in my property. She knew about it. She admitted that I didn't touch her.
Hold on, Mr. Keysberg.
So fast and speedy.
Hold on, Mr. Keysberg. Mr. Perdoso, anything Mr. Keysberg's indicated to you today, is that change the state's position on pursuing these charges?
No, Your Honor.
No.
So the state is still pursuing them, correct?
Yes.
Absolutely.
That's because of my past criminal convictions.
Mr. Keysberg, are you asking for a fast and speedy trial today?
I would like, I'm going to be posting my bond, Your Honor.
All right.
I'm going to hire my own lawyer and we're going to take this to trial.
All right. So let's get through your initial hearing. So you understand what your rights are?
Yes, sir.
All right. What's your mailing address?
Tuesday, Michigan City, Indiana, 46360.
Do you have a cell telephone number?
Area code 2.
I cut out the cell number so that Jen wouldn't call him.
All right, sir, please listen. Mr. Fredoso is going to advise you of the charges and potential penalties.
Thank you, Your Honor. There are 3 counts alleged in the charging information. Count 1 is strangulation, a level 6 felony. That count reads, on or about the 21st day of March, 2026, in LaPorte County, Indiana, Daniel Keysberg did unlawfully, knowingly, or intentionally, in a rude, insolent, or angry manner, apply pressure to the throat or neck of another person, in a manner that impedes normal blood breathing or blood circulation of the other person. That's a level 6 felony. It's punishable by a sentence of between 6 months and 2.5 years, with 1 year being the advisory sentence, as well as a fine of up to $10,000. Count 2 alleges domestic battery as a level 6 felony.
Bobby, I'm just checking. Yes, you. Bobby, I'm just checking. That's not you, right? Bobby? Is that you?
That count reads, on or about the 21st of March, 2026, in LaPorte County, Indiana, Daniel Keysberg did unlawfully, knowingly, or intentionally touch the person of Bobby Joe Callahan in a rude, insolent, or angry manner, being a member of the same family or household.
Because his old lady's name is Bobby. And you could just be using her name in this chat to trick us all. And that could really be you.
That count is a Class A misdemeanor. It's punishable by up to 1 year in jail and a fine of up to $5,000. I would note that the alleged battery is the same conduct as the alleged strangulation, so those 2 counts would merge. It's one is they can't be convicted of both of those 2 because they do allege the same actual conduct. And count 3 alleges intimidation, a class A misdemeanor. That count reads on or about the 21st of March, 2026 in LaPorte County, Indiana. Daniel Kiesbert did unlawfully, knowingly, or intentionally communicate a threat with intent that another person be placed in fear of retaliation for a prior lawful act. That a person be placed in fear that the threat would be carried out, and the threat was to commit a forcible felony. That count is a level 6 felony. It's punishable by a sentence of between 6 months and 2.5 years, with 1 year being the advisory sentence, as well as a fine of up to $10,000.
Mr. Kiesbert, do you understand each charge and potential penalties for each charge?
Yes, I do, Your Honor. First of all, I'd like to apologize. I didn't mean to come off like that. Second of all, like I said, I'm going to be posting my bond. I'm going to hire my own counsel, and I will abide by the no contact order. But I do want to proceed with this with trial because she does have medical issues. That's
fine, and that's your right. But you need to talk to your attorney about that, and your attorney will get the trial set for you. Okay.
Okay. Yes, Your Honor.
All right. So I'm noting for the record that Mr. Kiesbert's indicated he's hiring his own counsel. Your bond is set to $750 cash. That means you got to post $755 to bond out. If you do post your bond, you can use $750 of your cash bond to help you pay for and hire your attorney. Your next court date is going to be May 19th, 2026 at 12:45 p.m. That will be on the second floor of the Michigan City Courthouse in the Magistrate's Courtroom for Superior Court number 4. So that is your deadline to have your attorney hired by May 19th, and you are ordered to be in court in person on that date if you bond out. As a condition of your bond or release in this case, I am issuing a no contact order in favor of Bobby Callahan. You are to have no contact with her whatsoever, not in person, by letter, telephone, texting, through the use of any app, through any social media, through the use of computer, or through any third party, no contact at all. Do you understand that?
Yes, Your Honor.
All right. If you violate the no contact order, Mr. Kiesbert, you could be charged with an additional criminal offense. Do you understand that?
Yes, Your Honor.
All right. You are excused. Thank you.
Thank you.
Bobby, you know that's Indiana. You know that's where you live. You're trying to gaslight us. I know this is horrible. Is it Sandra's birthday that's May 29th? Is that right, Sandra? Somebody's birthday is May 29th. I think it's Sandra. We'll have to celebrate with her. Okay, let's look what I got. All right, we have one more. And this one is a case that we're going to keep our eyes on. So this case doesn't get resolved right now. We're going to see some messy family drama. And we are going to, this is like part 1. And I don't know when part 2 is. It's coming. I'll keep an eye on it.
Okay. We are here in cause number 406002 2512 PL 3417. Let me just make sure I've got everybody for the record. What is your name, sir?
Stanley Canola Jr.
Thank you.
Michelle L. Canola.
Thank you. Is there Kathleen Canola?
Kathleen Canola's right behind here.
Okay. And then wait, is there a Sherry Lynn Larson?
No.
Not here. Okay. So we got 3 parties here with counsel, and then we have 1 party pro se who fails to appear. Counsel, what's our status today?
Well, Judge, I believe we're here on...
Is dumpster fire a legal status by any chance? Judge, it's dumpster fire. That's the status. The dumpster is fully on fire right now.
On motion for possession. And I was going to have Kathleen testify as a witness, but I believe she's okay with staying in here because she's also a party, but not part of the possession. So I was going to go ahead and have Kathleen stay in here. But yeah, I believe that's what we're here for. It's my understanding we have a half hour to deal with possession of the property.
Mr. Walton?
Thank you, Your Honor. Yes, we are here as counter plaintiffs seeking immediate possession of the real property located at 8433 North 600 West in Michigan City.
And who has possession of it now?
Currently, Your Honor, Michelle Canola is occupying the property.
Okay. And there's no agreement to be had, correct?
No.
There is not, Your Honor.
All right, and counsel, you may proceed. I think it's your motion, right?
Yes, Your Honor.
Who would you like to call first?
Your Honor, counter plaintiff will call Stanley Canola Jr. as a witness.
To step forward. Raise your right hand. Do you swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth? Would you please be seated?
Good afternoon. Could you please state and spell your name for the record?
Stanley Canola Jr., STANLEY Jr.
Stanley, are you familiar with the property located at 8433 North 600 West in Michigan City, Indiana?
Yes.
And what relationship do you have with this property?
The owner.
And who did you purchase this property from?
I believe JP Chase.
And how much did you pay to acquire ownership of this property?
$21,000.
And roughly when did you acquire ownership of the property?
Early of 2018.
Sugar. I was going to say no. Kelly's birthday is in September. That's not right. That's incorrect. Kelly's birthday is the tip of my tongue. Is it September? It's not September.
At the time you acquired ownership of the property, where were you living?
5773 West 800 North, Michigan City.
And at that time, when you purchased the subject property, was your father, Stanley Canola Sr., living with you at 5773 West 800 North?
No, sir.
Was Kathleen Canola, your mother, living with you at that property?
No, sir.
Was your sister, Michelle Canola, living with you at that property?
No, sir.
Your Honor, I will show witness what's marked as Exhibit A.
You may approach.
Stanley, are you familiar with the document that I just showed you?
Yes.
And what is it?
It's the deed for the property.
Okay. Your Honor, at this time, I'll move to admit counter plaintiff's Exhibit A into evidence a certified copy of the deed to the subject property.
No objection.
No objection.
A is admitted.
Stanley, since purchasing the subject property in 2018, have you ever conveyed any ownership interest in this property to any other person?
No.
Have you ever given your sister, Michelle Canola, permission to occupy this subject property?
Yes.
Is Michelle's occupancy of the property determined by a written lease agreement?
No.
Was this a verbal agreement for her to occupy the
Yes.
property? Has Michelle ever paid you rent to occupy the property?
No.
Do you still give Michelle permission to occupy this property today?
No.
Have you ever asked Michelle to vacate the property?
Yes.
Your Honor, I'm showing the witness what's marked as counter plaintiff's Exhibit B.
You may approach.
Stanley, are you familiar with the document I've just handed you?
Yes.
And what is the document?
It's the notice to quit.
And when was this notice to quit served?
On December 8th, 2025.
And who was it served to?
Michelle Canola.
And what was the address that this was delivered to?
To 8433 North 600 West.
Thank you very much. Your Honor, at this time, counter plaintiff will move to admit Exhibit E into evidence.
Well, I would have to object, Your Honor. I don't know who Michelle Cuyols is. Here's Michelle Cannoli.
Yep.
I don't know who Michelle Cuyols is. And it's signed by Stanley Cannoli.
Your Honor, I believe this was a typo on the notice to quit as served by the sheriff's office. It's clearly made out to Michelle at the subject property, 8433 North 600 West. I don't believe any harmless typo of the last name would give Michelle any reason to believe that this was not served to her.
What's your legal objection, Mr. Woodcox?
I guess my legal objection would be that we're here with
You're amazing, Martha. You're amazing.
possession.
Monica, you're amazing too. Michael, you're amazing. All I knew was John Boy. You guys knew the rest.
Involving Michelle Canola. And the last name is a different last name for the notice to quit. So
I'm going to overrule the objection. You can obviously make that argument, but I'll allow the document in. Exhibit B is admitted. For the records, it shows the notice that Mr. Canola provided. Whether that's going to be a valid notice will be up to argument.
I think
Stanley, since
I think it's a really good idea. Guys, I have a really good idea. Tell me if you think this is a really good idea. I think I should buy a birthday cake for this stream every time one of you have a birthday. I'll eat it, don't worry. I'll take the hit for you because I never stop giving. But every time one of you have a birthday, I should have a birthday cake here, right? Isn't that a good idea?
Michelle was served with the notice to quit in December of 2025. Has Michelle vacated the subject property?
No.
Are you now requesting immediate possession of this real property back to you?
Yes.
Okay. Thank you. No further questions, Your Honor. I'll pass the witness.
Mr. Woodcox.
Mr. Canola, why did you and your father agree to put your name on the deed?
I purchased the house.
With what funds?
With cash in the bank.
Think you'd be able to provide a withdrawal from an account for $21,000?
Yes, I could.
So it's your testimony that your father did not provide those funds to you?
No.
They were your funds?
Yes.
Who has insured this property since 2018?
It was supposed to be insured with my mother and myself, but my mother never put my name on it.
Why would it be insured with your mother and yourself?
Because Michelle, I should say, could not afford insurance. That's why she was living in my house, because she couldn't afford a place of her own.
Why didn't you insure your house?
I'm not living there. I'm not renting it out. I'm not making any income off the property.
Do you have any other income property?
I do.
Do those tenants insure the dwelling that they rent?
They pay me rent, sir.
But do they insure the dwelling that they're renting from you?
No,
They pay
sir.
rent. He buys the insurance with the rent money, and usually they have their own. Guys, I had something today, which I don't understand, and that's fine. I don't have any desire to, but I think some of you will, and I think some of you will be stoked. Really, I had a homemade blueberry muffin from one of my favorite coworkers. Her name is Abby. She's just adorable. She is so adorable. Anyway, she made these homemade blueberry muffins with 30-year-old sourdough starter. She has 30-year-old sourdough starter that she's making bread. She made these blueberry muffins with it. It was freaking delicious.
Why did you have Michelle insure the dwelling that she did not own, according to you?
Again, it wasn't Michelle insuring it.
I may approach the witness, Your Honor.
You may.
Getting you what's marked petitioner's exhibit 1. Can you take a look at that for me, please? Who does it say is the owner of that insurance policy?
Says Michelle.
Is that the address of the property?
That is
Michelle
the address
currently
of the property.
occupies?
You are correct.
Does that show that Michelle took out that insurance policy on your property?
I don't know if it's actually Michelle because there's 2 L's in that. Her name's only got 1 L, sir.
Okay, well, we've already discussed the typos seem to be okay. But is there any reason why you would have Michelle insure property that you own on that dwelling and not you?
No, I told you exactly what I just said. I mean.
So she's insured it since 2018?
She has not. Because that.
When?
I'm gonna wait on that.
When did, if I may, Your Honor, I'd ask the petitioner's exhibit 1 to get in evidence.
Any objection?
No objection, Your Honor.
1 is admitted.
Didn't you contact the insurance company after all this got filed to cancel Michelle's insurance policy?
I canceled it after I found out there was an incident on the house with a tree that fell on it. And nobody told me anything about it.
Is that because you didn't have your own house insured?
No. Nobody told me anything about the house being damaged.
And you didn't have it insured, is that correct?
That's correct.
Michelle had it insured.
Okay.
Correct?
You are correct.
Who's been paying the property taxes on this since 2018?
My mother. And that was the agreement for her living in there with no rent.
The agreement with who?
With my mother and father to let my sister move into it.
So you purchased the house in 2018 for $21,000, and you had an agreement with your mother and father that Michelle could live in the house and not pay rent.
As long as the house was upkept and not damaged, which it is, and she paid the property taxes.
Was that agreement in writing?
Nope.
Would you be able to provide documentation where that $21,000 came from?
Yes.
Would you be able to provide that to your attorney?
Yeah.
And at your testimony, it did not come from your father.
Yep.
Has Michelle ever approached you about making repairs on the property?
Nope.
Have you ever made any repairs on the property?
I redid the house before she moved into it.
What did you have to do to it?
Everything. Furnace, air conditioner, redo the whole kitchen, both bathrooms, everything.
So if you had the agreement with your mother and father that Michelle could continue living in there, what changed?
Because the house is not being kept up. When you have a house that had working plumbing and all the drains worked, toilets worked, everything worked.
Ma'am.
And now you got black water standing inside the tub and the sinks and the toilets because nothing's draining. It's not habitable for anybody right now at this point, sir. And she has 2 young kids living there. And that's why I said, you gotta let me get somebody in there to try to fix it. And when I did, you can go back on the records, Michelle would not answer the phone, would not answer the door, and she called the police on me and then made a report saying I threatened to hurt her and the kids, which was a false statement. Never even talked to her or seen her that day.
I can't. I've learned the hard way that I have to stop. I can't put copyrighted stuff even on members only. I'll lose my channel. Right, Bill? I learned it the hard way. Members only doesn't mean I'm safe. at all.
When was the last time you were inside the residence?
We do have a couple channels that are not monetized, but members, it wouldn't be members only because it's not monetized. But we could do it there. I don't care if I get copyright strike there.
Probably 6 months before all this stuff started.
How did you get inside the residence?
Michelle let me in. She was there.
Have you since changed the insurance on the dwelling?
Yes, sir.
When did that take effect?
I'm not 100% sure on the date.
Are you the one that contacted Madison Mutual to cancel Michelle's policy?
I canceled Michiana Insurance, who I insure through.
That's the agent, correct?
Correct.
I don't have any questions or any further questions.
Mr. Walton.
Stanley, just to clarify, you purchased this property in 2018, correct?
That's correct.
Okay. And there is no written document conveying any ownership interest in this home to any other person?
No.
Is there any written lease agreement allowing Michelle to reside in the property?
No.
Okay. And you provided Michelle with a notice to quit?
Yes.
And she continues to reside there?
Yes.
Thank you. No further questions, Your Honor.
Yo, that sums it up. If JK was here, JK would say, yo, that sums it up.
Any recross?
No.
You may step down. Thank you. Any other witnesses, Mr. Walton?
Nothing further, Your Honor.
Mr. Woodcox?
I would call Kathleen Canola.
Please step forward. Raise your right hand. Do you swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth?
I do.
Thank you.
Yeah, then can you go ahead and state your name and address for the record, please?
Kathleen Canola, 5684 West 800 North, Michigan City, Indiana.
And are you related to Stanley Canola Jr.?
Yes, he's my son.
And you were married to Stanley Canola Sr., is that correct?
Yes, for 46 years before I lost him to an illness.
How long ago did he pass away?
Huh?
How long ago did he pass away?
He passed in 2020. He had to be 6 years in November 3rd.
Now, do you recall back in 2018 when this house was purchased?
Yes, I do, because my husband and I took a line of credit out to purchase the house and pay him back for it. And I've got the line of credit. It was taken out on our house. And the first payment that came out paid him back. And then we paid for the work to be done on it.
How much did you pay Stanley Canola Jr. for?
We paid him cash because that's what he wanted.
How much is supposed
that money? Was that intended to purchase the house?
Yes, that was to purchase the house. It was supposed to be put in her name and my name or her dad's name because his dad was going to ask him to have it put into his name before he got sick.
So there was an agreement between you, Stanley Canola Jr., your husband, Stanley Canola Sr., and Michelle Canola, that the house was going to be put in.
Michelle and the two boys, so she'd have someplace to live with the two boys. Because she's raising two sons by herself, because she lost her husband also the same year I lost mine.
Why was the house put in Stanley Canola?
Because he purchased it, because my husband didn't have the money right at that time.
Let me finish my question.
Yeah.
Why was it put in his name and not your name or your husband?
Because that's what he did.
Who was he?
My son.
He attended the closing and put it in his own name?
Because he purchased it, the people he purchased it from put it in his name. And didn't put junior or senior. It was just put Stanley Canola.
Why did he purchase it and not you purchase it if you had the money?
Because we didn't have the money at the time it was up for sale, and his father asked him politely if he would purchase it for him so he could have a house for Michelle and the two boys.
But your testimony is you provided the $21,000 for him to pay for it.
On the line of credit, that's the first thing we did was pay him back, and then we gave him money to start buying stuff to fix it with Jim.
So you're saying pay him back?
We paid him back in cash. His father did. He did right there at the bank.
So he paid for it with his funds first.
Right.
And then your deceased husband.
We got a line of
paid
credit.
back,
Yes.
is what your testimony is.
Yes.
Okay.
He knows his dad did.
Was there ever any
Mr. Attorney, sir, do you still require him to show proof that he purchased the house to his lawyer?
transfer of ownership via new deed?
No, his father wanted him to do it before he passed away, and he didn't. He just nonchalantly didn't want to do it.
Have you or Michelle, or have you paid for any remodeling done on the house?
Yes, we have. We've repainted, we've redone a lot of stuff in the house. And as far as the water, I talked to Jim the other day, and he said the way he hooked up the water, he put concrete where there wasn't supposed to be concrete. That's why everything backs up into the bathtub.
Who is Jim?
Jim is a neighbor that's down the road from us, that he purchased a house from my son too.
And when you say he put concrete where it didn't belong, are you referring
Right.
to?
Jim knows where it's at. He said if it gets into her house, her name or my name, he'd come and have it fixed.
You're referring to Stanley Canola.
Yeah, right.
So did he do remodeling to the home prior to Michelle moving in?
Yes, we did. We paid him and Jim to do it.
Has anyone else ever lived in that house other than Michelle since it was purchased in 2018?
I didn't hear you, Mark.
Has anyone else lived in the home since it was purchased in 2018 other than
because
Michelle?
it was an agreement between her father and myself. As long as she paid the taxes on it, the insurance on it, which the insurance to begin with was in his dad's name and my name. And when his dad died, Jeff proceeded to put it in her name. And so that's the reason it was in her name.
I mean, Your Honor, I may have Exhibit 1, Petitioner's Exhibit 1 back. I'm handing you what's marked Petitioner's Exhibit 1, which was the homeowner's insurance policy that Michelle.
Still, though, you know what Exhibit 1 is not? It is not a written agreement in any way, shape, or form. I rent. I can get an insurance policy right now on the house.
Had purchased. Is that your name and address there on the back as a?
Yes, it is.
Why is your name on there?
Because
I feel like trying to get an insurance policy on the lawyer's house. Taking him to court and saying, but I have insurance on the house. So that means I own it, right?
It's when my husband put me with him. We have everything together, Your Honor.
So that's the Stanley and Kathy Canola is
Right.
referring to your husband,
Right.
which is Stanley Sr.
It wasn't Stanley Jr., no.
Do you believe that Michelle should remain living in this house just based on the agreement that you and your husband, Stanley Jr.?
Yes, I do.
Michelle,
Yes, I do.
purchased?
Yes, because we purchased it for her and the two boys, Donald and Harry. Not for him.
I don't have any further questions, Your Honor.
Stan Jr.
Mr. Watts? Well,
Kathleen, your husband, Stanley Canola Sr., did not record the deed of this property in his name, did he?
No, because he trusted his son.
Thank you. There's no written conveyance of any ownership interest in this property to any person.
No, it was verbal.
Stanley Jr.
It was verbal, which my husband was a man who took person by their word.
Thank you. Is there any written agreement allowing Michelle to remain in the property?
Well, the thing was, we had an agreement with Michelle, as long as she paid the property taxes and the insurance on that house house was hers, and that's what she's done for 8 years, sir.
No further questions, Your Honor.
Nothing further, Your Honor.
thank you. You may step down.
I would call Michelle Canola.
You raise your right hand. Do you swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth?
Yes, Your Honor.
Thank you. Please be seated.
Michelle, go ahead and speak your name and address for the record, please.
It's Michelle L. Canola at 8433 North Satunda West.
Now, Michelle, when did you move into this house?
August of 2018.
I am outstandingly incompetent at my job. I just am. That's just me.
That was right. Not soon after it was purchased?
Yes.
Is that correct? What was your belief as far as the verbal agreement of the parties on you being able to move into that household?
The verbal agreement was I was supposed to pay home insurance and property taxes and keep up on all the upkeeping.
And Stanley Canola Jr. was in on that agreement that you could remain in the house?
Yes.
Okay. Do you know what was supposed to have taken place regarding the transfer of deed?
No, no.
Okay. But you understood that it was in Stanley Canola Jr.'s name, not Senior's.
It just said Stan Canola on it. It didn't say Junior or nothing on it.
But the deed address of the registered owner was Mr.
Yes.
Stanley Canola Jr.'s.
Yes.
Okay. Did you know where the money came from to purchase the house?
My mom and my dad.
They provided the funds to Stanley
Canola Jr.
Now, since
She couldn't, T, because the house has always only been in the son's name. It was never, ever in the father's name. It was only in his name since the beginning.
been living in there, have you or your mother been insuring that dwelling?
Yes.
Okay. Have you been paying the property tax?
Yes.
And that was pursuant to this verbal agreement that you guys all had?
Yes.
Are you asking that you be able to remain in the household?
Yes.
Do you have any kids that live in there with you?
I got 2 kids.
Have you been taking care of the maintenance and stuff?
Yes, I have.
And
I asked my brother about the water a couple times, 4 times, and he said it's my problem. I have to deal with it. I have to take care of it.
He told you to deal with it?
Yes.
What is
Plus, I redid I have new kitchen cabinets that needs to go in there that I have not put in yet. I have new toilets. I have new sinks and.
I see what you're saying, because there wasn't a junior on the deed. The father should have just gone. I mean, the mother should have, as soon as the father died, should have just gone down and transferred the deed into her name. But the address on the deed is the son.
Everything in there that I want to do, but I can't do it because it's in his name. I don't want to do it right now. And the tree that fell on there, I'm the one that had to get cut up. I'm the one that had to put the new roof on it, not him.
Did you turn that into the insurance?
Yes, I did turn it into the insurance. Okay. And he did come by and looked at the house when the tree fell. And it was like my 2 kids was there, my mom was there, and somebody else was there too at that time.
Have you ever been served with a 10-day notice to quit?
Yes, but that's not my name.
Have you ever had any discussions with Mr. Canola Jr. about remaining in the property?
No, Your Honor.
There's only one person in here that gets that.
Okay, sorry.
Title. It's not me.
Everybody knows there's two people in here with that title, too. Bill and Drunken Smurf. Thank you, Your Honors.
If you were ordered to leave the property, how long would you need to be able to do that?
A couple months.
6 months.
I don't have any further questions, Your Honor.
Mr. Walton.
Michelle, you do not own a deed to this property, do you?
No.
And this property was not deeded in your father, Stanley Sr.'s
No.
name? Okay. Your brother, Stanley Jr. has permitted you to reside at the property?
Yes.
Is there any written lease agreement?
No.
Okay. No further questions, Your Honor.
Any other questions?
No, Director.
Thank you.
Okay. Seriously, though, who else besides just me thinks that his lawyer did a freaking fabulous job? He asked each witness like 3, 4, 5 max questions, and they 100% covered the law. No fluff.
Any more witnesses?
Mr. Walton, any other witnesses?
Nobody, Your Honor.
All right.
He didn't talk about insurance policies. He didn't talk about electric bills. He didn't talk about who answers the door, who takes out the trash. He didn't talk about any of that. Superb, sir.
Here's my questions for counsel. As I was listening to testimony, I was trying to skim through to see what the significance would be for a notice to quit with a misspelling or wrong name on it. I didn't find anything real quick. Do you guys have any legal authority that would speak to that?
I do not, Your Honor.
I do not.
All right, let me hear arguments from Mr. Walton.
Your Honor, back in May 3rd, 2018, Stanley Canola Jr. purchased this property. The deed that we provided to the court is deeded in his name. It gives his address where Stanley Jr. was living at the time. Kathleen and Michelle have recognized that Stanley Sr. was not living at the property at the time. Stanley Jr. was living there. There's no written documentation showing that Stanley Jr. has conveyed any ownership interest in this property to any other person. Stanley has permitted his sister Michelle to reside at the property, but this was not pursuant to any written lease agreement.
And you're saying it had to be in writing to be enforceable? They're saying we had an agreement, we had a handshake. He's saying there's nothing in writing.
There is nothing in writing. I believe the statute of frauds would bar any admissible evidence showing an oral agreement to convey any ownership interest in this property. And I do have some case law if you would like at this time.
All right. Have a seat. Mr. Woodcox.
Your Honor, this has been a family dispute.
Your Honor, I got an insurance policy. Your Honor, he can't kick her out ever for the rest of her life. Because, look, I got an insurance policy and her name is spelled right. Yep. I rest my case.
For a period of time. It's kind of recently come to a head. Sometimes the law butts up to what is right and what is wrong, and sometimes it's up to the court to decide what is the right and moral thing to do.
That's what the lawyers just said, guys, out loud in court. Listen, Judge, I know what the law says. I do, because I'm a lawyer, so I know what the law says. But your job is not to follow the law. You have to think about what's right and wrong, not what is legal and illegal, not what is in the law books, Judge. That's your prerogative, Judge, to just listen to the law when you want to and just throw it out when you don't want to. That's okay. I wonder if he told his clients, guys, we got this in the bag. We got it in the bag. Don't worry. We have this insurance policy. This is a Perry Mason moment.
There's been testimony that the $21,000 came from Mr. Stanley Sr. and Kathleen's bank account, where they were to pay Stanley Canola Jr. For the proceeds of that house in order for Michelle to be able to continue living in it.
I think the testimony was they took out a HELOC or a home equity loan.
Yes,
correct?
yes,
Okay.
they took out a home equity on theirs, provided the $21,000 in funds for the benefit of Michelle to be able to continue living in the property.
I don't think legally that means anything. I think legally real estate has to be in writing, right? The ownership of real estate has to be in writing, right? Like, it has to be. The deed currently says his name on it, and there is absolutely nothing to dispute that. So that $20,000 could have just been rent for the daughter. Here you go. Here's her rent. Right? I mean, I don't know.
It is correct that the current deed in place says Stanley Canola with Stanley Canola Jr.'s address. The name doesn't say senior or junior. It just has the address of Mr. Canola, who's here today. But there's testimony as to the purpose of that purchase. It beats me why the owner of the property would not insure his property, other than the fact that he knew that he wasn't the rightful owner of the property. It was insured by Michelle. So we're just asking the court to allow Michelle to continue residing in the residence.
For the time being.
For the time being, I think we still have some other issues and counter filings that have been filed to maybe address.
So I think maybe, this is as far as I'll go. I think maybe legally, mom can sue him for the money she gave him. She took out this home equity loan, $20,000, and gave it to her son. I think in a civil suit, maybe she can sue him to get some of that money back. But I don't think that she can get all of the money back because the daughter did live there in his house. And I don't think she gets the house.
And Mr. Walton, you're wanting immediate possession at this time.
That's correct, Your Honor. In the absence of any written documentation that Michelle or Kathleen has any ownership interest in the property, I believe that Stanley Jr. Should have the right to access and use his property as he sees fit.
All right. Here's where I'm at. It's obvious to me that the family members are upset and angry and disagree on this. And that's not something I get to take into consideration. I have to look at what does the law say when it comes to real property and ownership and possession. And what I don't have an answer in my head right now is to what happens when you have a notice to quit that's has the wrong name on it. I don't know what the effect of that is. Even if it affected it then, it's clearly the notice to quit would start, it's obvious from this hearing that he wants her out of the house. So I don't think you can go back and now say, well, I never received anything from April 8th on, because it's pretty clear here that he wants her out of the property. And what I don't know is if the previous notice to quit was sufficient with the misspelling and whether or not she has 30 days then to get out from now.
Maybe if the notice to quit, which it normally does, says Michelle whatever and all occupants, then it would cover her. Let's look at the document. Can we see it, Judge?
The other question is, all of the other factors that we're talking about with the rent and the lack of rent and the payment of taxes. I've seen multiple family deals over the last 33 years that are not in writing, that are handshakes that wouldn't pass muster under the statute of frauds, that the family agreed to follow. I've seen families not agree to follow and say you have to have it in writing under the statute of frauds, and we're not going to go forward with that. So I'm interested in a memo from counsel about what the issue of the notice to quit would be.
This guy, the son's lawyer, already has it written up. He's already ready.
And then we can move forward from there. Right now, we're just looking at immediate possession. I understand the background that Mr. Woodcox was bringing out about the agreements and possible source of funds. That to me would go towards the whole other, complaint issue as far as ownership and whatnot of the property. But right now, we're just really talking about immediate possession. And the question before me right now is, was that notice to quit good enough? Or are we starting now and moving forward? So how long will it take you guys to get something on file to that effect?
Your Honor, I can have something by the end of the week.
Told you.
I probably need a little more time than that.
I was going to say 1 week would be minimum, I think. So today's the 8th of April. I'll give you to the 17th, which is the end of next week.
Don't worry, I have that docket. I just haven't gotten to it yet.
Most of the judges will be in training next week. So even if you file it by next Wednesday, I'm probably not going to see it till next Friday. So
that could explain why Judge Nathan has not streamed since the 7th. Maybe he got too much attention and he stopped streaming, or he was in training and he'll start streaming again. We'll see.
Speak to the issue of the notice to quit and any other case law or authority that you think would support either keeping possession or not keeping possession of the property right now. As to the total ownership and investment and who gets what out of the property, I think that is the long-term issue under the complaint. But right now, I think we're just dealing with possession. Will you agree?
I agree, Your Honor.
Do you agree, Mr. Woodcox?
Yes, I do, Your Honor.
Okay. So I'll look forward to your memos, and then once I receive those, I'll take this under advisement and make a determination as to possession. Okay.
Thank you, Your Honor.
Thank you.
His determination will be she has 10 days to quit. That's what it'll be. I mean, the only way, yeah, I know, it was pretty awesome, wasn't it? I know. Judge Middleton, I've been even playing him a little bit on here. I played his farewell when he left the courtroom, and I played his, quick 2-3 minute, whatever, how long it was, when he did his first live stream check of his new courtroom. And I don't play YouTube judges on this channel hardly ever anymore. I mean, it takes a lot for me to put a YouTube judge on this channel, because you guys get to see these YouTube judges pretty much on every channel. They all repeat the same cases. They just have different commentary. But when you come to this channel, you see a different judge than you see anywhere else. Who else plays? That was Judge Stallink? No. That was Judge Reagan? No. Sanford? I can't really remember now. He was definitely Judge Stallink. That was Judge Stallink. I'm the only one I know who shows him. Judge Fish used to be just me, but now everybody's showing him. We saw earlier today Judge Ditton. You only see him here. We saw Magistrate Link. You only see him here. I love him. I do. Judge Cutie Pie Josh. I haven't played him in a while. You only see him here. So, I mean, Judge Middleton did have an awesome stream today, and if you have time, you should go and watch it. He's just such a wholesome. It's just, you feel good watching him, and I think he had a sob sit. Yeah, see, Eileen, Simpson, Boyd, Middleton, every other channel plays those same judges in the same clips. They just add different commentary. So you've already seen the cases before. The only person who plays all my judges before me is Bill at American Courts. When he streams every day. His daily streams. And his videos that he also puts out every day. Oh, wait. Bill, you're slacking lacking. He does play Judge Fleischer every day, and we thank him for that. Thank you, Bill. And I'm just going to say it. Judge Fleischer was here first, before anybody else was playing him. So if you haven't subscribed, subscribe. Because you're going to see judges. Oh my gosh, Judge Reeves. Michael, you're right. Judge Reeves, Judge Wilson. Nope. Williams. Yep. Kathy. Judge Kathy from Harris County. Judge Caulfield. So good. So good. I'm missing a Georgia judge. Besides the girl. Can't remember her name. I'm missing one. Judge Reeves, Judge Caulfield, Judge Williams. Oh, the adorable judge in Dawson. I can't remember his name because I call him the adorable judge. You only see him here. So, yeah. I mean, JK is here. Hello, sir. How are you? You are a law advisor on this channel, and we had a lot of questions today. But don't worry, JK. Don't you worry, because I pretended I was you, and I answered all the questions flawlessly. And any legal advice I had given during this stream, you should absolutely just take. And if I gave away any medical advice, follow it. Do that too. If I gave out any cooking advice, you try it. If I gave away any drinking advice, you should definitely listen to me because I'm an expert at that drinking thing. So guys, thank you for coming out. I appreciate it. We're going to do this again in about 5-6 hours, maybe 7. We're going to do a Georgia case with a different judge than all of them, I think. I think it's that other judge. Remember when we did the boys? Oh gosh, okay. We did the boys who were in detention. The tables are like an L, and the judge was sitting. The female judge was sitting up. And then there was like seats along the wall where Mom was at. Mom did not want custody. Mom just wanted visitation. The state had the boy. One of the boys was 18 and mentally challenged, and because he was turning 18, he had to sign paperwork to stay in treatment or care, I should say. Do you remember that judge? Anybody? I don't know the name, but I'm just asking. Do you remember the judge that I'm talking about? You can only see her here, and those cases here, which I haven't gotten in a long time. There's a technical reason why I stopped getting her docket, which I could get. I'm just lazy. But tomorrow morning we're going to see Hall Court 102, which is normally trials. When I say we're going to see Hall 102, it's a trial. But it's a 1-stream trial, not a 17-stream trial. Don't worry. We're going to see that in the morning. It's pretty interesting. It's not like it's not custody or divorce or anything like that. Don't worry. I'm going to sneeze. So I'm going to say goodbye. Thanks for coming out. Oh no. Whew. Okay. Nope. It didn't pass. Bye guys. Thanks for coming out. I appreciate it. I'll see you in a couple hours. Bye.
happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in